perfectly appropriate. Scott.
Scott Schick from the New York Times. I know you don't want to talk or you talk about the legality of destroying the tapes or the legal issues there, but I wonder if you could comment on the fix that Attorney General Mukasey finds himself in when he's sort of promised to say at some point what he feels about waterboarding, whether it's legal or illegal, whether it's torture. It does seem to me that his dilemma reflects one that is behind a lot of the behavior that we're talking about today, which is that certain things were done with high-level approval in 2002. In practice, the administration has steadily moved away from those things. They haven't waterboarded since 2003, but there were, as we believe, there were legal opinions in 2005 justifying the things that were done in 2002. The tapes were destroyed in 2005 that presumably show the waterboarding. All this is sort of trying to preserve the legality or preserve the immunity of the people who did that in 2002. That seems to me a real bind. I just wonder, what does this look like from Mukasey's point of view?
I'm going to try that one myself. I've written, and I think this is right, that I was surprised Mukasey didn't say the following in his hearing, that waterboarding is torture and is unlawful, but he promises that anyone who did it in reliance upon OLC opinions will not be prosecuted. Wasn't that the easy way out? Now, Scott, I think it's not because of potential criminal exposure that he didn't do that. I think it's two other reasons. I think first because in order to find that waterboarding is torture, he would have had to repudiate the rationale of the OLC opinions lurking behind it, namely that severe physical suffering must be prolonged. And if he repudiated that, it would mean the end of other techniques that have become controversial. It would be hard to single out waterboarding. And the second reason, I think, is because it would mean that he would be saying that folks like Steve Bradbury had given bad, transparently wrong legal advice, and now the administration is continuing to, push for the appointment of Steve Bradbury, and it puts Mukasey in a very tough position to be saying, I want the Senate to confirm someone whose legal advice I think was completely wrong-headed.
Yeah, but that's exactly what he should be doing. He should call it as he sees it.
No, but
wherever the
I'm just trying to respond to Scott. Why isn't he doing that? I think these are really
this is one possible interpretation, that the legal advice was palpably, demonstrably wrong. So wrong, but it was a first-year law student's exam, you would get an F. With all due respect to Marty and everybody, this ain't necessarily so. It is entirely possible, Scott, for the executive branch, and I've gone through this exercise in other contexts, to take a different, you look at the given statute, you slice it, you say, look, there are some things that are clearly barred by the statute, and they have some zone of discretion, in the regulatory law called Chevron discretion, and there are many interpretations of a statute. As long as they're all within the zone of reason, 1 is the best, number 10 is the worst. You as the agency flip back and forth among interpretations. You have to go through, certain organizational steps to get there. But it doesn't mean, quite aside from the point that you and I to hold anybody retroactively liable criminally, which would be unthinkable, you don't say we messed up and now this is the right interpretation. You just say we shifted, we re-exercise our discretion. We don't even need to opine on the issue whether or not the previous exercise was wrong, because the United States is a sovereign, and Justice Department and OLC as a body should not be in the business of sort of promiscuously repudiating yourself.
Well, it's not promiscuous.
If you don't need to do that, you can shift to another interpretation, you can buttress it, and you don't have to say anything about what happened in the past. That is a perfectly defensible position. Justice does it all the time. Environment Division does it. Tax Division does it. Antitrust Division does it. OC does it too. The mea culpas are not legally compelled mea culpas. The mea culpas that people are asking for are politically driven mea culpas.
Yeah, I think that that approach is justifiable in some situations, but here it's crazy. I mean, here where the original opinion had already been withdrawn by the Justice Department at the end of 2004, I was shocked to learn that in 2005, OLC was giving opinions that was still trying to defend some of the techniques that were so controversial and which we had stopped using. And I think that the approach that that we're going to pay a terrible price if we don't take the approach that our moderator so wisely urges we should have taken already, which is to say, for the Justice Department to say, the earlier opinion was wrong, and that these types of techniques are forbidden. They don't even have to say they're torture. They can say they're cruel, inhuman, and degrading treatment. They can do a lot of things, but they can take us out of this terrible bind we are as a policy matter and be consistent with the law.
Can I, Marty?
Yes.